Welcome, folks, to the second session of our summer series on green public procurement. We're really glad that you could join us today. It's been really an honor to be able to share lessons learned from around the world on green public procurement, a very, very important topic, emerging topic in public procurement internationally. Just to emphasize, we had one session before. It was on the 23rd. And that session, we talked about emerging international patterns in green public procurement. And that session was recorded, and the recording is available on Public Procurement International on the program page that we have for this summer webinar series. On Tuesday, we'll be talking about next week on July 30th, we'll be talking about state and local issues. And it's really an extraordinary array of solutions that are emerging at the state and local level across the United States. So I hope you can join us for that as well. That session is going to be like today. It's going to be at noontime on Tuesday. But just as we discussed in the earlier session, just a couple administrative points. I'm Chris Yukins. I'm a professor of government procurement law and the Lynn David Research Professor in Government Procurement Law at GW Law School. This is part of a webinar series sponsored by GW Law School, and the recording, besides being available on Public Procurement International, is also going to be available on the GW Law Government Procurement Law Program YouTube page. We have both questions and answers available. That you can use that function, but you also, and it's a little bit more fluid, you can use the chat function. If you have questions as you go, Tom and Rob and I will be responding. And I should just note that because some of us are advocates, the statements that are being made today are statements that are made in our personal capacity. Carrie Waters is one of the panelists from Tuesday, and she's here she'll be listening along, and she was able to respond to some of the harder questions that we got the last session. So Carrie, welcome joining us. We have over 300 registrants. To give you an idea of the breadth of interest in this area, we have over 300 registrants from 63 countries around the world. This is really emerging as an international issue, but one where solutions oftentimes are coming from state and local governments, as we'll see in more detail on Tuesday. So our agenda for today is Rob Anderson, who's a retired staff person from the WTO. I'm going to give more detail on his background in just a second. He'll explain how trade agreements can facilitate green procurement, balancing against the importance of open markets. Tom Daley, who's from DLA Piper, and I will assess how common initiatives in green procurement raise trade issues and how those might be best addressed. And then we're going to have discussion questions, both among the panel and among the audience members as well, I hope, that we'll be looking for your questions to discuss towards the end of this hour. Now, what we learned on the last session on Tuesday, it really confirmed what Tom will be talking about, what Rob will be talking about from studies that are being done internationally, is that there are common strategies that we're seeing for environmental sustainability for green public procurement. One's based on improved planning for green public procurement in the procurement process, one based on contractor qualification, where contractors might not be qualified if they aren't able to address the greenhouse gases that are attributable to their goods and services. One based on eco-labels, and I'm using the term eco-labels very loosely, and I apologize for that, but we need to have a term that captures what really are technical standards for environmentally sound products. And so we're just using the term eco-label to capture that, but it's a very broad range of standards. And what we learned on Tuesday is that for a variety of very interesting reasons, including problems of enforcement, governments are steering towards a heavy use of eco-labels, those environmental standards. And I think that was a very important outcome, very important lesson learned from Tuesday. Another approach is to, in the technical evaluation, to weigh price and other quality issues against what the environmental or what the greenhouse gas emission impact really is of a product. And that technical weighing is both very complex, and it could be very difficult to attain. And we'll be talking about some of it's obviously the brass ring. It would be the most wonderful thing if we could bring it into procurement on a regular basis, because it would, in essence, nudge the marketplace towards a greener approach, to nudge the entire marketplace, because that's occurred in other initiatives like accessibility for IT. By requiring IT accessibility, that information technology being bought by the government is accessible to persons with disabilities. That's nudged the entire IT marketplace towards accessibility. But there are a lot of costly hurdles that have to be overcome before that can become a regular part of the public procurement world. The last approach is life cycle costing, considering what are the life cycle costs that are attributable to greenhouse gases, for example, and taking that full potential cost, including externalities, the potential costs outside the procurement system. Well, how will this impact the environment in general? That type of life cycle cost approach is the fifth approach that we're seeing commonly emerging. So we'll be talking about these different strategies over the course of today. So first, I want to start and welcome Rob Anderson, who's a very dear friend of the program. Lovely to have him here to join us here. He's been a part of several of our webinars and regularly teaches with us. He's a part-time academic and independent consultant and a trainer on matters relating to competition policy, government procurement, intellectual property, and the multilateral trading system. He currently lives in Sarasota, Florida. He previously worked in the Secretariat of the World Trade Organization from 1997 through 2019. He held a position there of senior counselor and team leader for government procurement and competition policy in the organization from 2005 through March 2019. Rob led trainings all over the world, led workshops all over the world, both to teach folks about how the WTO government procurement system works, government procurement agreement works, but equally important to teach best practices, all over the world. He did a wonderful job leveraging his position at WTO to help spread the good word on what are best practices. And increasingly, that's an important part of trade agreements in procurement. How do we use them to spread best practices? And Rob did an outstanding job with that. He holds a title of honorary professor in the School of Law at the University of Nottingham in the United Kingdom. He serves as an external faculty member in the International Public Procurement Management Program at the University of Rome, Tor Vergata. It's a major program there on procurement that's led by Gustavo Piga. Its sister program at the University of Belgrade in Serbia, and the Academy of International Economic Law and Policy at the European Public Law Organization in Athens, Greece. He's got the other credentials are here on the slide. I just want to emphasize Rob is also a prolific author, and we'll be talking about a piece that he just co-authored that relates directly to the topic today. So we're very, very privileged to have him join us. Also joined by Tom Daley from DLA Piper. He focuses his practice on assisting companies who do business with federal, state, local governments, on litigation matters, grants, investigations, environmental matters, and regulatory counseling and compliance issues. He successfully litigated bid protests before the U.S. Court of Federal Claims and the U.S. Government Accountability Office, GAO. That's our major bid protest forum here in the United States, as well as size protests before the Small Business Administration and Office of Hearings and Appeals. Tom also represents contractors in contract administration matters and with claims under the Contract Disputes Act. He assists clients in internal investigations brought by inspectors general, and Department of Justice investigations related to actions brought under the False Claims Act. That sounds like a very broad portfolio, I know for many of you, but it's actually all directly relevant to green public procurement because these are various enforcement mechanisms, contract disputes, fraud claims potentially. We touched on very briefly in the last session, but these are enforcement mechanisms that will help make green public procurement work. Tom also advises clients on emerging environmental and climate change requirements. Tom is really one of the leading authors in our community on the emerging federal initiatives in green public procurement. And he also writes and speaks on developments related to agency sustainable procurement policies. He's counseled clients regarding the FAR Council's proposed disclosure of greenhouse gas emissions. He'll be talking about that, and I'll be talking as well about the proposed rule and climate-related financial risk rule and its proposed sustainable procurement rule. As I said, he's a very widely published author in this area, and I'm absolutely delighted that Tom could join us today. Thank you, Tom. So, Rob, I'm going to hand it over to you.
Thanks so much, Chris. Wonderful to be here with you and Tom and with everyone present. And I really appreciate the opportunity. This is a great contribution you make, Chris, to international dialogue on these issues. It's really terrific, and I'm very pleased to support it. So this is a quick presentation I'm about to make. It's based on a similar presentation done recently at the University of Nottingham, and on a joint article with my colleague and collaborator, Antonella Salguero. And we'll give you the citation for that later in the 2 or 3 slides from now. Okay, so I want to make clear right from the outset, I actually think that the parties to the WTO agreement on government procurement are thinking very constructively about potential contributions in this area. And really, and overall, the present agreement on government procurement in the WTO contains a lot of good approaches and good possibilities to promote sustainability and environmental and climate change adaptation. And so there's a lot going on in this space that is very positive. Nonetheless, some of the old-fashioned concerns remain about possible protectionist tendencies, and we'll come to those towards the end of the presentation. Okay, so yes, thank you. So I want to begin actually by pointing to a development in the theoretical literature on international trade, but also very, very much in current policy initiatives that I think is really very constructive and long overdue. And this is the idea of what we call multi-purpose trade policy. And this is a recognition that that trade agreements, don't have to just serve the old traditional objectives of ensuring an efficient international division of labor through trade liberalization. It's not to say that those objectives don't remain important. They are important. But trade agreements, increasingly we're seeing, can serve other valid, legitimate, and very important objectives. And it should be all about using the tools that are at our disposal in the international community to promote the actions and possibilities that we need to see come into fruition. And right now, that's critically mitigating the global climate crisis. So, but it can also include things like bolstering labor rights, addressing inequality, helping countries to build resilient supply chains, safeguarding national security. All of these things have to be considered and are legitimate things to think about in constructing modern trade agreements. That's really the point of this idea of multi-purpose trade policy. And you'll see this reflected not just in academic writings, but very much in, the speeches of Ursula von der Leyen and the USTR, Catherine Tai, and so forth. So next slide, please, Chris. Thank you.
Can I just ask a quick question, Rob? So this
Sure.
is actually a problem that or an issue, not a problem, an opportunity that we're dealing with separately, because my colleagues and I in the American Bar Association are working to revise the Model Procurement Code. And in that revision process, there's going to be a new statutory materials, maybe new regs, but there's also a lot of lessons learned that are being churned up during the revision process. What your experience in the WTO, this codification or recodification process becomes a means of exchanging best practices, exchanging lessons learned. What's some of the best ways that you found in your work through the WTO? What's some of the best ways that you have found to disperse, to exchange those lessons learned?
Well, thanks for that, Chris. I would say, it's through the back and forth discussion in the Committee on Government Procurement, and also through the back and forth discussion that we used to have in those regional and national workshops that you mentioned in your very kind introduction for me. And so, it's through dialogue, and the dialogue can then feed into into future revisions to the Agreement on Government Procurement and other trade agreements. The GPA, the WTO Agreement on Government Procurement, is not intended to be sort of a rigid instrument that is fixed forever. It's intended to be a work in progress. It's intended to evolve over time. This is very, very explicit, and the present version of the agreement, the 2012 version, like its predecessor, contains this built-in commitment to eventually hold a review and negotiations and discussions to improve the agreement over time. So this is really a terrific thing. It's a terrific opportunity. I know it takes courage for governments to kind of muster their resources to undertake those discussions. And I think it paid off very handsomely in the 2012 revisions. In other words, I think the 2012 version of the agreement is greatly improved, including with respect to consideration of environmental sustainability objectives and other objectives, the things I've mentioned here on this slide: good governance. The 2012 version of the GPA refers specifically to the efficient and effective management of public resources. So what you're seeing is that whereas this used to be an agreement that was front and center about trade liberalization, and in a passing way had some positive effects in other areas, to really what is, to me, I think this terminology, multi-purpose trade agreement, is quite useful and applies directly to the GPA 2012. I think the GPA 2012, yes, it's good for trade, but it's also good for the efficient and effective management of public resources. That's quite an amazing thing. The signatory parties to the GPA want this agreement to be useful not only for trade, but for the public resource management, good governance, environmental sustainability. And I would argue that the GPA even has positive implications for human rights, to the extent that it's ensuring non-discrimination and fair procedures for individual suppliers. This is something that's good for women-owned businesses, other minority-owned businesses, to ensure a level playing field. So that's so thanks. Sorry for a long answer to your very useful question, but I think that all of this progress has been made, and a whole lot more progress can be made through further discussions. And in just 1 or 2 slides from now, we're going to come to, those ongoing discussions. So the GPA. So in addition to the new language, new and very open language on environmental sustainability that is built into the 2012 version of the agreement, and which already provides a lot of scope for countries to implement pro-sustainability measures. In addition to that, the 2012 revision also led to the creation of this GPA work program on sustainable procurement. And, this is a terrific and timely thing. And all credit to the parties to the agreement for having done this in 2012. I think it was prescient on their part. And it provides an opportunity for further progress. And by the way, this work program, there's also a work program on small business or SMEs and other issues. The work programs are intended to serve 2 purposes. One is to contribute to the positive administration of the agreement, even right now at present, and the other is to contribute to the future evolution of the agreement. So the GPA work program on sustainable procurement, it calls for these things, which are noted in the slide. I don't need to read them out, but it calls for a review of the objectives of sustainable procurement and of the ways in which sustainable procurement is integrated into current government policies. And it directs the committee to identify measures and policies that are deemed to be best practices to promote best value for money, and that are consistent with parties' international trade obligations. So, this is a major opportunity for them to move forward. I'm not saying it's easy. I happen to know it's difficult to reach agreement and common positions on these issues, but I think a very real effort is being made. So if you turn to the next slide, we can highlight one of the. So now, I think the new EU-US joint catalog of best practices on green public procurement is really a terrific positive development. And I suspect that many participating in this program are aware of this, but in April 2024, the EU and the US jointly issued this extensive catalog of best practices for promoting green public procurement, drawn from experience in their respective jurisdictions. And this was certainly not done only for the purposes of carrying forward this WTO work program, but it was done for broader purposes than just that. But it certainly holds the potential to enable to form a very useful input into the work of the WTO work program on sustainability, which I've just mentioned, and to carry that forward. And so I just quickly on the catalog, in my view, it's an extremely useful compendium of best practices and related initiatives by itself already in its own right for the promotion of GPP. And, you know, that in itself is a really useful contribution. Number two, it does affirm and uphold explicitly the requirement that GPP procedures be implemented in a manner consistent with the parties' international obligations, including under the government procurement agreement of the WTO. So I think that's you know, these are really positive features. I will say that on the second point, I think the world needs more. It's very, very good and constructive that the parties affirmed this principle, and I really congratulate them for that. It's really important. But what we need now is guidance on how to do that, how to ensure that things like eco-labels are used in a manner that is consistent with parties' international obligations. How do we actually do this? To my mind, you know, this calls for guidelines that go further than just the present joint catalog, as useful as that is, and really delve into current practices in the EU, in the US, and also in other jurisdictions as well, and really set down some markers as to how to implement sustainability through these various measures in a manner that is consistent with international trade obligations. And I think that the WTO Committee on Government Procurement, through its work program on sustainable procurement, can play a very significant role in this work. That's the sort of the theme and conclusion of this article that I mentioned by Antonella Salguero, my colleague from Paraguay, and myself, and the citation is given there. And I think, Chris, you very kindly uploaded that on the sort of website for this seminar as well. So that's really great. So enough, and I promise to come to a conclusion in about 2 minutes.
So Rob, can I just ask a quick question on the
Sure.
GPA process? So the WTO.
Sure.
So I worked on as you know, I worked on the UN model procurement law for about 10 years. And I thought, you know, I was the American voice. It wasn't a big deal. But one day we would meet regularly in Vienna. And one day the subway was stalled. And so I showed up about 20 minutes late for the meeting. And I walked into the room. It was the experts meeting, and it was completely silent. I was stunned. Completely silent. It suddenly dawned on me that my job was to be the jerk. My job was to ask the annoying questions to try to drive the discussion forward, and a role that I embraced with relish. And it worked because there were other people who were good conciliatory types in the working. Is there that kind of dynamic available in the WTO working group where you have somebody really pushing hard from the outside saying, let's fix this now? Is that possible?
So the answer is yes, that is absolutely possible. Now I'm speaking now, and obviously I'm retired from the WTO. I'm just speaking in my personal capacity based on my recollections of the 15 years of negotiations. Um, but absolutely, there's a great deal of and you know, individual countries or jurisdictions or the European Union, for example, can decide to be champions of green procurement and can push very hard. And it can sometimes put other GPA parties a little bit on the defensive. But to me, that's a constructive dynamic. And it was that dynamic that led to the GPA 2012. And uh, it wouldn't have happened without those, you know, free flowing discussions. And you know, I will say also the EU and the US were the leading, you know, proponents of different positions, but there was very extensive and good presentation also by many other GPA parties, the Canadians, the Swiss, the Japanese, the Koreans. So many were involved, and it was truly a free-flowing discussion, and it was, you know, very much about best practices in public procurement, in addition to being about trade promotion. So, so absolutely. And by the way, incidentally, I think your contribution to the UNCITRAL work was a highly constructive one, and you know, that's another good thing that happened, and also through our dear friend Caroline Nicholas, and we should be proud about that too. And all of these instruments now are certainly the GPA, the UNCITRAL model law, and to an increasing extent, I would argue, the World Bank guidelines are converging and in a very, very useful way. And there's a lot of scope for, you know, cross-fertilization across international organizations as well. The OECD is doing very good work. So we're coming to the end of my presentation, but thanks for the question, and that's great. And this is just a slide to note that yes, all these great things, and they are great things, have been going on in terms of discussions on international discussions, especially between the EU and the US, but also in the GPA committee with other GPA parties. And you know, this is certainly contributing to better understanding in the world procurement community. That said, the you know, the concerns about protectionism in this area have not gone away. And this is just a little quotation from the annual report for last year of the WTO Committee on Government Procurement. And it does note that a number of delegations, quite a good number, I believe, I understand, raised concerns about how the U.S. had been implementing the Build America, Buy America Act, which, as you well know, is part of the Infrastructure Investment and Jobs Act, the so-called bipartisan infrastructure bill. And you know, they are worried. Basically, they are worried that the increasingly strong emphasis on Buy American measures and policies is potentially undermining the trade-related objectives of the GPA. And now, to be fair and to be clear, the U.S. said and says that this concern is wholly mistaken, and that adequate guidance is there to ensure that the BABA and other measures are implemented in a manner consistent with international trade agreements. And that's been, since back to the 2009 American Reinvestment Act, that's been the formula to ensure to avoid outright conflicts in this between countries in this area. That is to include those magic words, these measures shall be implemented in a manner consistent with U.S. obligations under international agreements. And so far that has been able to avoid sort of to avoid kind of really glaring conflicts in this area, and that's a very good thing. So I'm just making people aware that this discussion is also happening in the background, and I think it's fair to say that tensions could increase further if there is a change of U.S. administration. That's the most that I will say about anything concerning the present presidential race. But I also want to underline one substantive policy point here, and that is that a reversion to old-fashioned protectionism in the government procurement sector will raise costs and thereby can undermine the transition to green public procurement and to a more sustainable future. So we need, the objective of competition, the objectives of competition and free trade in the government procurement sector, can be synergistic with the objective of fostering sustainability and climate change adaptation. And so it's worthwhile the parties doing some very careful thinking in this area and doing their best to avoid, to manage, because let's face it, it's not only the United States. If we read the recent statements by Ursula von der Leyen, which were quoted, I think, in the previous seminar, and in other GPA parties as well, there are efforts to there are renewed efforts to favor domestic suppliers. So we need to manage this properly to ensure that those efforts don't undermine the objectives of good public procurement policy and even the transition to a more sustainable future. I think I'm now coming to my last slide, unless, yes.
Yeah, I want to just to explain to folks what it means in practical terms is, so the Build America, Buy America, we talked about this in the last session, Rob, is that the BABA Act says that infrastructure presumptively will go to American companies, infrastructure purchases done with federal grants through state and local grantees. That's what BABA says. But as you point out, it says we're going to honor our international trade agreements. That's what Congress said. In the implementing materials from the Office of Management and Budget, it says, yes, but if, for example, Maryland wants to buy a really good product that has a very low greenhouse gas emission signature, if Maryland's a member of the GPA, if Maryland wants to do that through its procurement function, the manufacturer from, let's say, Sweden, which is through the EU, is a member of the GPA, they have to go through a waiver process. They have to go through a waiver process to be able to enforce their own rights under the GPA. And those waivers are very difficult to move through. So in essence, the Biden administration has raised a barrier. So that's a problem. And just so the audience understands what's going on politically here in the United States, President Biden, as I'm sure you heard, said he's not going to run for election. Vice President Kamala Harris, over the last few days since Sunday, has been embraced by the Democratic Party. Vice President Harris is stronger on climate issues than President Biden. So we have a very sharp contrast now between and we're going to talk just now, Tom's going to be talking, and we'll be talking about the position that the Trump administration is likely to take on issues of green procurement versus the public positions that Vice President Kamala Harris, who's now the presumptive Democratic nominee, has taken on these climate issues. Very, very sharp contrast.
Absolutely. So to conclude, I am pointing out that the GPA 2012, and this is what is covered in this article by Antonella Salguero and myself, which is just out in the current issue of the Public Procurement Law Review. So the present GPA 2012 does provide broad scope for implementation of sustainability criteria and requirements, already. Further to that, the new EU-US catalog is a major breakthrough. It's very useful in its own right, and it's also potentially can now be given to the WTO Committee on Government Procurement, or tabled before the WTO Committee, and used as a basis for further work. And so all of these things are tremendously positive. Still, there are, as we've just been discussing now with Chris, there are significant concerns in the air. The international community needs to think through how do we successfully promote sustainability and GPP while managing the tendency to invoke local preferences and ensuring those don't get out of hand. Okay, so how do we do this? Well, maybe we'll come back to this in questions, but just very much in brief, I think we should be using the tools like the GPA and other trade agreements, by the way, to create and I think we're already moving down this path to create a community of like-minded countries, that is the GPA parties and the affiliated countries, who care about competition and fair procedures and non-discrimination in government procurement, and who are equally committed to sustainability and to achieving and to climate change related objectives through their procurement systems, and talk with each other about how to do this in the most useful and most universally acceptable ways. And the opportunities are there. A thing like the EU-US catalog is a great contribution. The GPA committee is there. The work program is there, so, I think I'm very hopeful for the future, but it will take effort. Thanks a lot, Chris, for this opportunity.
Thank you very much, Rob. So, Tom, I'm going to turn it over to you.
Yes, thanks, Chris and Rob. Appreciate the opportunity to be here today and to cover some of the common approaches in green procurement. As Chris mentioned, I'm in DLA Piper's government contracts practice. My client base is companies in the private sector who do business with federal, state, and local governments, as opposed to working directly with agencies. So some of my comments and views might be colored by that experience, and it's a little bit different of an angle to look through. So here we've got 5 of the most common approaches. Chris covered these at a high level earlier, so I'm going to walk through each of them and discuss what's included in there. So at the planning stage, there's a few different ways you can do it. In the US, you typically don't see it, but in Europe, and this is discussed in the joint catalog as well, there are certain jurisdictions that actually have requirements that governments direct at least a certain percentage of their annual spending towards green procurement. And what green procurement means in that sense is usually defined within those jurisdictions. You can also have emission reduction targets and net zero spending goals that are set at the federal government level. So these are the broad goals that all agencies have to work to meet. But agencies are also able to set their own individual sustainability goals and plans. At least in the US, they have annual climate, or not annual, but they have their own sustainability plans that are out there that discuss specific actions that an agency is taking in the context of climate change and sustainability. There also are procurement level examples. So a few years ago, a very popular one was the USPS decision to buy zero emission vehicles. So during the acquisition planning and market research stage, building in considerations related to sustainability. So rather than buying internal combustion engines, they went and purchased a certain amount of zero emission vehicles. We see it with the Department of State too, which you can think of as a lot of physical assets, embassies. So they are in the process of retrofitting those buildings to make them more energy and water efficient. Another one that's gotten a lot of coverage recently is the Department of Defense. They've been purchasing or entering contracts to purchase carbon-free electricity. And that's part of their efforts to meet the goals relating to CFE or carbon-free electricity set by the federal government, but also their own goals that they've set, such as having microgrids on each installation by, I think it's 2032. So agencies are doing, and they're spending money to do it to meet their own goals. And to touch briefly on BABA, as background, a couple of years ago, the U.S. had two bills that were passed that set up multiple programs with billions of dollars of funding for clean energy technologies. So one of those is to build out an EV charger network in the U.S. so that it would facilitate the use of EVs in America, because you'll have more access to the chargers. As part of that, there are these domestic content requirements that Rob discussed, where a client was planning to go after these grants, and they're looking at their supply chain. And in order to be eligible for that funding, it might not have this exactly right because it's been a while, but the steel in the housing for the EV chargers had to be manufactured in the US, and 55% of the components used in the EV chargers had to be manufactured in the US. So there is that sort of building into the clean energy projects the US government is funding considerations related to purchasing products that are manufactured in the United States. Contractor qualification. So the idea here is that the government, the US government at least, considers responsibility in each of the award decisions that it makes. And it's in FAR Part 9. There's a number of factors that are considered. But here you would be building in environmental considerations related to responsibility. There's a proposed FAR rule relating to the disclosure of greenhouse gas emissions and climate-related financial risk. Chris is going to cover that more later in the presentation, but at a high level, it requires contractors with more than $7.5 million in prime or direct contract awards to disclose their scope 1 and 2 emissions. And then it imposes additional requirements on major contractors or those with more than 50 million in those prime awards. That's not the only way you can do it. You could also have a sort of certification that contractors would need to make when they submit a bid that they have not committed certain environmental violations or are compliant with environmental regulations. So you would be screening out non-compliant offerors as being non-responsible and therefore ineligible for award. The eco labels, there's a slide later that will discuss this in more detail, but it's encouraging or requiring agencies to purchase products and services that meet the requirements of a green labeling program. Technical evaluations, that's the fourth one we have here, and that is building in minimum requirements or evaluation factors related to sustainability in the award decision. Last year, there was a draft RFP that came out for a large government-wide procurement known as Alliant 3. And what they did there was to build in points to be awarded if an offeror was disclosing their scope 1 and 2 emissions, and additional points for scope 3 emissions. So right now in the US, the rule is it's a proposed rule. It's not required to disclose your greenhouse gas emissions, but agencies are taking the matter into their own hands by saying, okay, we're going to have a point scoring process of 0 to 100 points. 3 points will be for offerors who are disclosing scope 1 or 2 emissions, and another 3 points for disclosure of scope 3 emissions. So having the award decision build in factors that relate to environmental considerations. You can also do this through eco labels. So it's a different category on here, but the idea would be that if your product is not compliant with the applicable eco-label program, it would be non-responsive to the specifications in the RFP, and then it would get knocked out in the technical evaluation. And separately from those two, you could also do this on a procurement by procurement basis, such as writing in energy efficiency requirements or an ability for a product to be reused a second time. The last one, life cycle costs. This is starting to be considered in award decisions, but it's not widespread by any means. There's an upcoming proposed rule in the United States that would require agencies to consider the social cost of carbon when making award decisions, and where practicable and feasible, to give preference to the proposals with a lower social cost of carbon. That proposed rule is interesting because it was originally drafted in September 2023, but it's been under consideration within the federal government since then. It's not clear why or really the status of that rule. It's a long time to be under review for 10 months. And also around that same time, the Biden administration came out with a directive for agencies to consider the social cost of greenhouse gas emissions in high impact procurements, such as when the government is purchasing large energy consuming products and systems. So that seems to be set up as a sort of pilot program where they'll be able to gather lessons learned and to implement it in the future. I see this one as having a big potential to impact award decisions. So you think about a current solicitation now, you might have like basic factors in there, technical, past performance, price, and you're inserting into that a sub-factor for price, similar to how you would have a price reasonableness determination. Is the price too high for the government to pay? Or a price realism evaluation, which is the price too low? You would then potentially also have a life cycle cost analysis where you would adjust upwardly or potentially downwardly the price offered by a offeror. So just another basic example, let's say it's a lowest price technically acceptable procurement. You have two offerors, offer A, offer B. They submit firm fixed prices of $100,000 for offeror A and $105,000 for offeror B. The agency, as part of its evaluation, considers life cycle costs, and it upwardly adjusts offeror A to $110,000 such that it's no longer the lowest price technically acceptable offeror. I think there you could have a potential bid protest ground of the agency unreasonably evaluated the life cycle costs of client A's price. It should have only been upwardly adjusted by $2,000, or kind of the inverse of that, offeror B's price evaluation was unreasonable because it was not upwardly adjusted. It should have been upwardly adjusted by $8,000 and it wasn't. So it's not a new novel type protest ground argument. It's still built into a challenge to the price determination. But I think that's one area that you're likely to see some litigation. And just in terms of next steps, the Department of Defense has a model for consideration of life cycle costs. It's not used across the government, to my knowledge, but there is some development that's going on there, and there's going to need to be a process whereby the data that is needed for those analyses is requested from the offerors when they're submitting their proposal.
Just quickly, Tom, on this, the reason we have Steve Schooner's, my colleague Steve Schooner's picture on here is just to remind me that on the program page, Steve has written extensively on these various options and on environmental sustainability. On the program page, we have a link to a compendium of his articles alongside his picture on the program page.
Yeah, thank you, Chris. So I won't spend a lot of time here since we're getting close on time, but Rob covered this. There's also a webinar on publicprocurementinternational.com. So it's a really great guide. I'll echo everything Rob said. It covers from the planning stage through award, and it's worth going to take a look at. here we've identified a few next steps and potential issues. So Chris, if you could actually jump to the next slide, I'll just run through it all at once. We've identified and color-coded the 5 different areas based on the difficulty or challenges associated with each. So green being the easiest, red being the most challenging. So just to go through these, the planning process, this is already happening. I identified a few examples earlier of where that is happening. It's going to be a learning process for agencies, and it's going to be iterative. So you want to see some sharing of data publicly and between government agencies as to how best to do this. And you also need to ensure it happens, right? It's not just paying lip service of, yes, we considered the social cost of carbon in the market planning stages and decided not to do it. So having some accountability there to make sure that it's being considered appropriately in the planning stage. The contractor qualification. So there are real costs to contractors to inventory and disclose their greenhouse gas emissions. In my practice, we'll work with a multinational corporation, and they have disclosure requirements in the EU. They're working with me on the proposed FAR rule, other lawyers in the US in a rule issued by the SEC relating to disclosure, and then there's another disclosure regime in California, so maybe it's another set of lawyers helping them with that one. And it can get expensive and complicated quickly. So developing a contractor qualification system so that companies know what to expect when they're entering the public sector in a given country, and to help to keep the burden down while also ensuring that there are environmentally responsible offerors submitting proposals. And just this is another example that not related to environmental considerations, but we do work with clients who are based in the US and they want to enter 10 potential markets, and we'll work with local counsel in those countries to help them develop a plan. So they'll look at costs to enter those countries to enter the public sector. So if you have contractor qualifications that are set really high, such as you need to have emission reduction targets and have them validated by the SBTi just to be eligible to do government work, companies might shy away from that and not want to spend all the money needed to do that. Eco labels, promising to get there. That's going to be on the next slide. Technical evaluation, we talked about a few different ways to do it. So there, it's coming to a conclusion on how best to do it. Again, that's going to be a learning process, and officials are going to need training on that. Public procurement officials don't always have that same background in climate change or environmental considerations that all of us on the webinar do or may not, may be developing that. So there's got to be some training there to teach that new skill set. It can be hard for somebody with no training or experience in this to evaluate a claim that an offeror is going to be net zero by 2040 or some other emission reduction target that they're representing in their proposal, and to know whether that's a legitimate action the contractor is taking, or if it's more of a greenwashing type of claim. For life cycle costs here, you still need to have that the model built out as to how costs will be considered, and it would be beneficial to have a consistent approach there, because you're asking contractors to dig up this data to include it in their proposals, and that can take time. It can slow down the procurement process, and if you have an offer or a competition with hundreds of offerors, you may want to hold off until a second or third phase of the competition to evaluate those costs. So there's things that need to be worked through as this becomes more of a routine consideration in the procurement process. Chris, if you could move to slide 52, please.
I just want to quickly, if I could just throw in here on the life cycle costing. The one of the problems and the reason that we have this in yellow is life cycle costing, if it's done rigidly, can in essence perpetuate monopolies or oligopolies in a marketplace, because oftentimes the strongest market players are involved in the regulatory process in setting up how life cycle costs will be assessed. In the US, at the federal level, about 60% of procurement is done using competitive negotiations, competitive dialogue, and there's going to be more play in in a competitive dialogue or a competitive negotiation. That's not true in the European Union, for example. In the European Union, only about 2 or 3% of the procurements are done, the major procurements are done using a competitive dialogue, competitive negotiations. They're more likely to use a formula. The formula for life cycle costing creates a risk of oligopolistic behavior, excluding those who don't fit that formula. So it's just an issue that we want to flag, and that's why we have it in yellow with regards to life cycle costing.
All right, so just a quick note on eco labels, and then I'll turn this over to Chris. So in the US, there was a final rule issued earlier this year, it was effective in May 2024, and it requires agencies to procure sustainable products and services to the maximum extent practicable. And that's the key language in the rule. There were existing requirements, but now the FAR Council has tried to give agencies less discretion and to require them to procure those services to the maximum extent practicable. It applies to all procurements, including micro purchases, although there are certain exceptions for things like weapon systems. And it's also important to note that not all products and services at this time are sustainable. So if you have a unique solution doesn't exist in the market, it's not going to be covered under this rule, because the rule it identifies certain statutory and regulatory programs as providing the definition of what is a sustainable product and service. The main one being the EPA recommendations program, which covers about 40 eco labels. And that's a significant difference than the 450 roughly that are available globally. So if you have a product or service that's covered under one of those eco labels, the agency must acquire products and services unless it's not practicable. So the final rule set out 3 instances where it's not, and that could be the price. It's too high to buy one of these sustainable products or services. There are performance issues or time considerations. You can't get it delivered within the required schedule. So the other thing on this rule that was important development is that the burden for identifying which products and services are covered by the programs is now on the agencies. And they need to identify it in the solicitation, evaluate it, and then enforce it in the award decision. And that's important because in the past, we would have clients come to us and they would identify the predecessor rule to this and say they're asking for information that which products and services are covered under the purchasing programs. And I don't even know where to start with the purchasing like I have no familiarity with it. So by placing the burden on the agency, they have to, in the planning stage, which we've talked about, go through and identify the applicable eco-label programs, identify it, and then the contractors will submit in accordance with the solicitation requirements. The delta between the 40 and 450 reflects that the EPA takes a more stringent view on which, and maybe I'm reading a little bit into it, which eco-labels it considers to be legitimate. They have a framework. Chris is going to talk about this more, but they believe the framework that they use allows for transparent criteria and a consistent approach to evaluating eco-label programs. But even if, notwithstanding that framework, the rule is not going to develop to 60 eco labels, 100, 120 in any quick manner, because the EPA, to expand its program, it needs to go through its rulemaking process. The FAR Council, they froze the list of eco labels as of October 2023. So it's not going to be a rapid evolution where you jump from 40 to 400 eco labels overnight. So Chris, would you take us through that last bullet point there on the different frameworks?
Sure, glad to. Just quickly, and I apologize, we're going to go a little bit over, maybe 10 minutes or 15 minutes over, so we can address some of the open questions. The EU, the Court of Justice for the European Union, issued a decision called in Max Havelaar, the Max Havelaar case. It was the real name of it is the North Holland, but it had to do with coffee machines being installed in government offices in the Netherlands. Max Havelaar was the standard that was used, the fair trade standard that was used. Long, complicated story, but the bottom line is the Max Havelaar decision in the Court of Justice of the European Union laid out a very, very good approach to technical standards of this kind, saying, for example, the technical standards, the goals have to be clearly stated. The meetings that you have to discuss the technical standards have to be public. Anybody, if they have questions about the technical standards, they have to have an opportunity to raise those questions. So the Max Havelaar decision, which was then carried into the 2014 directives, into Article 53 of the directives, very, very thoughtful approach from the Court of Justice, then carried into the European directives about how these kinds of standards have to be derived. And I think it's a good lesson for all of us. It's a good comparative lesson. Tom, I just want to talk briefly about the rule that you alluded to before that stalled. It's the proposed rule that would say that contractors will not be qualified if they can't present data on their carbon gas emissions. Excuse me, the greenhouse gas emissions. And it's based on an executive order. And so this was issued in November 2022, and it hasn't gone forward. It's been stalled. One of the reasons may be because of a development in the Supreme Court that all of us could see coming, where the Supreme Court struck down the Chevron doctrine, we had a webinar on this a couple of weeks ago, where we talked about that in the Chevron doctrine, there's deference to agencies in their interpretation of the law. Under Loper-Bright, which is the case that replaces it, the Loper-Bright decision for the Supreme Court issued just a few weeks ago, that Loper-Bright decision means that courts are going to be much more probing, and they may go after this rule. This rule will impose hundreds of thousands of dollars of costs at least on major contractors. As Tom's been discussing, it's a complicated process to compile data on greenhouse gas emissions. And as a result, the courts might strike this down. In the meantime, a conservative Congress stepped in. The House of Representatives proposed, and finally the National Defense Authorization Act included language stopping the Defense Department, which is the major procuring agency in the U.S. government, stopping the Defense Department from compiling, gathering this information from traditional defense contractors for a year and non-traditional defense contractors forever. So conservatives in Congress have said, no, this is too expensive. This is going too far, and essentially made it impossible to gather the data necessary, not only for contractor qualification, because that's a first step to actually evaluating greenhouse gas emissions in a technical evaluation. No, Congress has said we don't want the data gathered at this point. So you see significant political opposition, in part because of the costs. And you see the parallel. The same thing happened to the SEC. The SEC pulled back on its proposed rules regarding what public companies have to gather and disclose because of the same type of cost-based opposition to forcing companies to gather greenhouse gas emission data. California, though, as Tom alluded to, California is requiring that of companies that have more than $1 billion in revenues. So you see this disparate advances where some governments are moving forward and other governments are stalling. There's also, by the way, a parallel initiative that was slowed in the European Union, the same type of requirement for corporate disclosures of greenhouse gas emissions. So a lot of things moving in parallel, but because of cost issues, some seem to move forward faster than others. Now, I just wanted to go through a few. Tom already alluded to the how we weigh these various initiatives, these various strategies. I do want to stress that there are things that are unpredictable that really help dictate. So, for example, if you have a procurement system, which is true in most of the world, where awards are based on low price, it makes a lot of sense to use an eco-label, to use an environmental standard, because that's easy. Just you plug it in the specifications, you take the lowest price product that meets those specifications. Where a technical evaluation, where you're weighing price, quality, and green procurement issues, that's a very complicated approach and maybe much more difficult to implement. And Jelly Molino talked about that in the first session, that as a result, developing nations that have less sophisticated procurement systems they may be leapfrogging ahead of the United States and the European Union just by broadly using eco-labels. It's very, very, very interesting. So I wanted to talk about this middle issue, that Abby Semple raised in the first session. She quoted Ursula von der Leyen, I've been doing some researching on the president of the European Commission, by the way. She turns out she had a lot of very distinguished American ancestors, a very interesting part of her background, besides the fact that she's fully fluent in English. And the question I have for you, Rob, is there a mechanism under the GPA? She has signaled here, you see from the quotation, and Abby raised this in our first session, Abby Semple raised this. Is there a mechanism under the GPA to deal with what we see, what you've referred to as soft protectionism, where you can see a new directive, new procurement directive in the European Union might well include protectionism, a European preference? Is there a way within the GPA to deal with this issue prospectively, a problem that we see coming down the tracks?
Thanks, Chris. Well, absolutely, there is. And you know, in the GPA committee, within the committee, any party can raise any question it wants to of any other party, and you saw kind of a hint of that in the statement that I quoted from the annual report. But yes, countries can ask for a presentation on the new initiative. Now, in practice, a lot of that tends to go on kind of behind the scenes, country to country, before it surfaces in the GPA committee. But there's nothing to prevent it from being put on the agenda for discussion in the GPA committee itself. And may I add, you know, that's also very much the kind of thing that could be directly discussed in the work program on sustainable public procurement. And you know, and for example, the second, if I may, forgive me, Chris, if I may, the second bullet point on the slide here, which green procurement approach is least likely to trigger trade concerns, which are most likely to trigger international concerns? You know, these are the kinds of questions that ultimately, it would take a lot of work. It would not be easy, but the Committee on Government Procurement in this work program could provide some answers to those questions. And that would be, you know, a tremendous way to carry forward the dialogue beyond what they've already done. So sure, you can talk about these things, and I hope countries will.
So Tom, a big part of our job in the GW program is to gather together. It's like being a sort of a wheelhouse. You gather together as a lot of the different legal type of solutions. If I could just briefly, as we close out here, talk about the last two bullets here. Let's say you represent that Swedish vendor who wants to sell a product that has very few greenhouse gas emissions through the supply chain. The scope 3 assessment is very, very low. Let's say you represent that vendor, but they're encountering problems getting the agency to take that seriously during the planning process under the rule that's already been published. The final rule says you're supposed to take this into account. Is there a remedy that you can use as a lawyer to try and force the issue in the U.S. government?
Yeah, so it's more challenging to file a protest that would require an agency to consider the scope 3 emissions of a product, as opposed to if the agency voluntarily wrote in a specification that said that the scope 3 emissions for this product need to be X or below. There could be a challenge for a competitor that doesn't meet that to say it's an unduly restrictive specification. It's not reasonably related to what the agency needs. It's not a legitimate requirement. And then the GAO and the courts here generally are pretty deferential to the agency so long as they can articulate that this product, we actually need lower emissions for whatever reason. But if a client came to me and said, we want them to include a specification that includes consideration of scope 3 emissions, it wouldn't be a protest that I would recommend to them. It would be trying to get in front of agency decision makers earlier in the process before there is a draft RFP to explain why your product or why scope 3 emissions should be encouraged. So it's a more of a soft approach than a litigation measure, because you really need the agency to go ahead and affirmatively decide that that's in their best interest to include the Scope 3 emissions.
Going back to Rob's point before, Tom, so you're talking about a discussion rather than a lawsuit.
Yeah, that's right.
Very interesting. Okay. Anything else you'd like to add, gentlemen? Thank you all. I want to remind everybody and thank very much for the audience for joining us. Remind everybody we have our last session on state and local. That's going to be on Tuesday at the same time. It's going to be 12 noon Eastern, and it's going to be 9 a.m. Pacific, and it's going to be then 1800 Central European time. And we'll have experts from around the country talking about state and local solutions for green procurement. Thank you both. Thank you for an excellent webinar. Have a good day, everyone. Take care. Bye-bye.
Thank
All right,
you so
thanks
much,
all.
Chris.